Again, everybody, this is Monica Kariuki, and you are on Echo FM on radio and Facebook. Today we have the best lawyers in Kenya and in USA, because Meg practices both in Kenya and USA. I think I've gotten questions and concerns from a lot of people that have requested I bring in lawyers so we can talk about properties in Kenya. And as diasporians, you know, sometimes you have sent money home, it didn't do what you meant it to do, or you've bought land and something happened to it, or whether somebody occupies it on it because you're here. So today we want to go over all that, all the questions that you people in diaspora and those of you in Kenya could have related to property. So that's what we are going to discuss today. So with me, like I said, I have the best lawyers in town. So I do have ladies first. I have Margaret Kariuki, and she is an advocate of the High Court of Kenya with postgraduate qualifications in law from London School of Economics, and also in gender, culture and development from University of Southland C. Margaret practices law in Mombasa, where she has a law firm by the name of Style Onguyo Kariuki Advocates. And then we have my good friend Job Vega. So Job is an advocate partner at Warohio, Kowade, and Nganga Advocates. He is one of the oldest, or is it the law firm is the one of the oldest indigenous law firms. Practices areas are majorly commercial litigation and conveyancing. So welcome Margaret, and welcome Job. I appreciate you guys so very much for having time to come and answer these questions that diasporians have. So welcome to Echo FM and welcome to Diaspora.
Thank you. Thank you for inviting us.
All right. Okay. So most of these questions are questions that I've gotten from people. So we're just going to go over these questions. So, and the first question, we all want to acquire wealth and property. But in Kenya, how can one safely buy legitimate plots, land, or houses? And I'm going to start with you, Margaret. Actually, before you answer that question, is it okay if I can call you Meg?
Actually, yeah, Maggie.
Maggie?
Yeah, it's fine.
And Job, it's okay if I can call you Job? Job?
Yes.
Okay, awesome. Okay, so Meg, can you go ahead and answer that question for us, please?
Yes, that's fine. That's fine. Can you hear me?
Yes, I can hear you.
All right, good.
Okay, so would you like me to start that, Monica?
Yes, ma'am, please.
Okay, so when it comes to plots or land or houses, the assumption that the same strategy is required when you're trying to be. So when you're buying a plot, you may have to use a different strategy from when you're buying a house or even just a piece of land. So usually with let's start with land, for example. Most times we buy land with the intention of having a portion of it to be a farm, and you have an intention of the other part for you to build on it, right? So you probably would be buying an acre or more. And when you do that, the first thing you would have to do is to find out who is the owner of this plot. Who is the owner of this plot? And the best way to do that is to find it out if there's a title deed. It's not all the time that a piece of land has a title deed. But let's look at the scenario of if it has a title deed, what should you do? What are you looking at in the title deed? Most of us are used to a piece of paper which actually has, and Job, you will agree with this, we are used to the word title deed, so that if somebody shows you a certificate of title, a certificate of lease, we get confused and we are like, is this still a title deed? Yes, it still is, because it still confers ownership. Only that it might be different. You might be buying a lease and somebody else might be buying it to freehold. So the first thing to do is to look at the document you're presented with. If it's a title deed, the first thing you look is the name. What does the name say? Is the person who is selling to you the same person on the title deed? That's the first thing you check. Because many times it could very well be that the person selling to you is the wife or the husband. It could be the son of somebody who is either alive or deceased. So you start with finding out, so who is named on that title. And after that, you look at the acreage. The title will always have the acreage there. Because if you're buying a 1 acre piece of land and the title says 10 acres, in fact, it usually talks in terms of hectares, then you would question whether you would need now to know, so what will happen? Because you're only buying a portion of that piece of land. So what is the next thing that you would need to decide? Is there going to have to be subdivision? What are the costs of that? When you subdivide, are you going to get the portion that you want, the exact piece that you want? And also, you need to check out the encumbrance section. Encumbrance is a big word, but it only means to see if there's anybody else who has some sort of claim. The bank would have a claim. If the bank has a claim, it will be written there very clearly, charge. The bank, you could have finished up paying, the person selling to you could have finished paying the loan, but maybe it still hasn't been discharged. So these are the things that you need to look at when you see, when you're beginning to buy a property. You first examine the title.
Okay.
Yes.
Job, how do we even go about, some of the things that Maggie is saying could actually not, they're not so familiar with me or a lot of people in diaspora. So how do we even go about that? It's almost sounding so complicated that to just buy a piece of land, I probably may need an attorney present to look at all that. Can you dumb it down for us?
Let me try.
Okay.
Yes, that's complicated, but it's not. Because, just like when you're purchasing any other item, you need to be sure that the person who is selling to you is the owner. So as Maggie says, you need to confirm who is the owner of this property that I am interested in. And then once you, of course, ask yourself that question, then the next question would be, what confers ownership on this person? What proves they're the owner? So then that means that then you look at the title document that confers ownership on this person. And once you do that, of course, then you'll see the details of the title. You see the name of the registered owner. You see the acreage, as Maggie said. You see whether there is any other person who has an interest on that land. That is the encumbrances section. So those details will be self-evident. But if you're not too sure about the documentation, you're not too sure about the process, it is advisable to engage a professional. And this is where the lawyers come in, because we have that training and we have the knowledge to be able to decipher some of these details that are crucial for you as a purchaser or as someone who is interested in acquiring a property. So as much as possible, engage a professional, engage a lawyer, engage a surveyor. The surveyor will help you to confirm the extent and the acreage, and the layout of the property. So, look for professionals to guide you through this process.
Okay.
That way, the process will not confuse you, so to speak.
So all that is good and dandy, but the thing is, I may not know if this is a fake document. How can I tell this is a fake document or not a fake document, Job?
Yes, thank you, Monica. That's a very good question because we have cases of fake documentation and they're rife in our area. So what you do is that you need to carry out a search. with the lands office, the relevant lands office, because different titles for different areas will be registered in different registries, lands registries. So you need to undertake a search as part of your due diligence. Besides, of course, establishing who the owner is, where the property is located. Doing that search ensures that you get confirmation from the government that according to the government records, this is the person entitled to this property. This is the person we recognize as the registered owner. So that search is very important. It's a formal confirmation from the government that the details appearing on that title match what we have in our register.
Okay, so what about...
Yeah.
Okay, go ahead. I'm sorry. I didn't mean to cut you off. Are you finished?
Yes, yes.
Okay.
Sorry, I just wanted to add there that that's sort of an assurance from the government that the details that we are giving you, if they tally with what is on the title, then you're all good. The documentation is fine.
So, yeah, go ahead, Maggie.
Can I also add to that? So I agree that of course, you get the government assurance, and that's as much as you can. And to add on to that, there are situations where the government itself, there are situations where you can have 3 people holding the same title. And that happens if the registry is involved in some type of fraud. So it has happened in situations where you go buy a piece of, like there's this case where an individual approaches a bank, buys a piece of land, actually a building in town, in Nairobi town. He gets everything done. He does his searches, he gets everything done. He gets the title charged. And then the guy moves on to another bank and does the same thing, gets another new title from the registry, goes through the process of registering a charge again, and then he does it with a third bank and a fourth bank. So you see, in that particular case, the victim in this case is the banks, 4 banks in this case. But to be honest, to carry out such a fraud, it would have to involve somebody at the registry, and to a certain extent, you have no control. So such cases usually end up in court. Obviously, with a lawyer, they would help you deal with a situation where there's double allocation, and now the court would have to decide between the 2 holders of a title, because they came from the registry. So the court would have to make a decision as to who therefore is the legit owner.
And that was going to be my next question, because I was going to ask, about contested titles. So, so walk us through the process of a contested title. What do we have to do if the title is contested? So
what happens? It takes a while before you realize that you're holding a document which is fake. In most cases, if you buy a piece of land and you probably go and do what we call kumwagamare, now you're like, okay, now I've got the piece of land, I want to start building. It is at that very point that now when you've mortgaged your mare, that somebody will come and say, hey, that's my piece of land. And then they show you the document and you begin to debate. So you begin to say, no, I bought it in 19 this, the other one is like, no, I bought it on this day, this person sold to me. At that point, if you're not able to settle amongst yourselves, because sometimes you will find out maybe one of the children sold the piece of land without the knowledge of the family. So sometimes if you're not able to solve it at that level, now you would have to escalate to the court. So you would go to your lawyers, they would draft for you the documents, and pretty much what they would be asking the court is to determine who the real owner of the land is. And the court sometimes, and I believe also Job can add to this, sometimes if you're both holding documents, sometimes the person who had theirs first, so that if I had mine in 1996 and yours came along in 2006, the court may likely award me to, depending on whether there was any fraud or anything, the court could say that I'm the one who is the rightful owner, the person who was first in time.
Okay.
Yes.
Yeah, Job, you want to add to that?
Yes, I wanted to jump in there and confirm. Yes, indeed, that is known to happen. You have multiple titles. You have 2 or more. so to call them original genuine titles issued by the Lands Office. As Maggie says, of course, with the involvement of officials there. So that is not to happen. Indeed, I have handled litigation involving such a scenario, where someone had an original title, they sold to a client of ours. Our client started putting up, multiple dwelling units, sort of a gated estate. And later on, this other person shows up with another title, issued earlier in time. You can imagine that situation. Here you are, you think you own a piece of land because you have a title that has been, confirmed by the Lands Office as genuine. Then someone else shows up with an older title, one that is earlier in time, again genuine. And so the matter ended up in court, and the court ruled in favor of the original, the earlier title. And so our client had to reach an agreement with this person, on what to do about the buildings that were already on the land.
Right.
So it's a very untidy situation. But you can see, our client got compensation from the government. The court ordered that the government was to blame for having issued multiple titles by the same property. But you can see the messy situation, one can find themselves in. Because when you're investing in land, you do not want to get into litigation, to be dragged through long-winded court cases and all that. You want to invest and, get your returns from your investment. So that happens, yes.
So then, Job, I think you just answered my question, because anytime you're purchasing land, there's a lot of money involved, especially now, they've all skyrocketed. So if you purchased land and it was the seller's mistake, so you as a buyer, you find out that this title deed is actually has other owners. So do we lose money, or what happens?
Yeah, it depends at what point you realize. Have you, gone the whole hog in a transaction? Have you paid out money, or have you just realized as you are doing, your due diligence, or had you paid, say, 10% deposit? So it's crucial at what point you come to the realization that there's a problem. If you've already paid the whole amount, then much more complicated, because getting a refund from the person that you paid to again can be a complicated process. They may have already utilized that money, put it into other things. So getting that money back then becomes another court case.
Tedious court case. Okay. So what about Meg? If I can come to you, what about if I've bought land, I have a legitimate title deed, everything looks good, but then I live in America, so 2 years down the road I go back and I find that somebody actually built on my plot. How can I vacate that person? Or now what do I do?
Okay, actually the question you asked, I think it tends to happen a lot. And fortunately or unfortunately, you have to get the legal process involved in removing somebody, especially if they put up a building. The truth is, we lawyers believe really the court should be the last option. So of course you would try and enter into some sort of agreement with this person and say, okay, then buy me out. Buy me out at the proper market value. If they are not able to, then now you can go to court. You can then now seek an order where you're saying that this person has put up a building in my property, and now at that point you should have a document. This is where the title comes in. You should be able to show the court you're the registered owner of that property, and this person who is not known to you or is a stranger in as far as that plot is concerned has erected a building on your plot. So you'd be asking for them to be compelled to remove that building at their cost. Of course, that will not happen in a day, probably not even in a year, but eventually that is the kind of order you'll be seeking to get from the court. And it happens that people do get such orders.
Wow.
But it's a very unfortunate situation.
So you're saying it's okay. So right now I'm just trying to understand. I'm sorry to probably use this word, but bureaucracy, in Kenya, because if I'm presenting my title deed that this is my land, why is it going to take such a long time to evict someone that has built illegally on my land? Job, can you explain that?
Yeah, well, we now have laws governing the process of eviction. You cannot just wake up one day and decide you're going to throw someone out. So you have to, issue notices for them to vacate. At what point they're going to probably bring whatever, justification they have for being on your land. Then you would have to go to court to get that court order to have them evicted. These laws were passed, to ensure that the process was orderly, because it had gotten to a point where, people would hire goons, take the law into their own hands, and in the process, lives would be lost or maimed, property would be damaged, and so there was need to have an orderly process. So it may take a bit of time, but it's all for the interest of justice and the proper running of things. So you do not have people taking the law into their own hands. Yeah.
Okay. All right. So let me ask you again then. We've seen companies that sell houses, plots, and these are probably legitimate companies. They look big, when you look at their rapport, they've been selling plots for a long time, but they sell you a plot again that wasn't legitimate. Is it possible in Kenya to sue a company? Job?
Yes, it is possible to sue a company. Companies are, legal persons, so they can sue or be sued. But before you get to that point, you must do your due diligence on this company. Who are they? Do they have a track record of other, transactions that they have handled, other projects that they have put out there and, carried out successfully? So do your due diligence. And again, as part of your due diligence, look at the title documentation that they have in respect of the land that they're selling out. So is it in their names? Is it charged to a bank or a financial institution? Have they undertaken, subdivision? Do they have the right documentation for subdivision? So before you put your money, on the table to a company like that, do your homework. That will save you a lot of heartache. Okay.
So Meg, let me ask you, women especially, they get into chamas, or sometimes, people join circles, whatever, so they can acquire property that way, right? But, most of these chamas is you put money as you go, right? But, if you decide you want out, or maybe, let's say you've gone ahead, the chama has bought land, but they haven't subdivided it, as we agreed. So if I want out because I want maybe my piece so I can sell it or do whatever I want with it, what is the process and, how do you get out?
So if they have bought a piece of land and the land is in their name as a self-help group, probably it may well be in the name of maybe 3 people holding it on behalf of the rest. So if the land is not yet subdivided, the challenge now would be, or rather I can already see a situation where they would now say, then you have to foot the cost of the subdivision. Depending on how much acreage you bought, it's probably $300 going up, depends on the value, the surveyor and all that. So if you agree between the chama and you that you'll mamia the subdivision, and then they can transfer to you, that is also possible, that can be done. The challenge would come if now they do not want that to happen. So again, the other way would be, then you would say, then value the property that belongs to you and let them buy you out, let them pay you the equivalent. And you can always go off and buy another piece of land somewhere.
Wow. Okay. Job, do you have any different experience on that?
No. That is quite correct. Yeah. So if it's a self-help group, because that's not a legally recognized entity, so the land is likely to be held in the names of officials. Maybe the chairman, secretary, treasurer. Those are usually the ones that are given the mandate by the rest of the members to hold the property on behalf of the rest. So, have that understanding that this property is held by these people on behalf of perhaps a wider group. And when you have that understanding, then you also know that there could be pitfalls. They may at some point perhaps not be able to carry out a subdivision, to completion, or they may have misunderstandings amongst them, and the process of sale is then affected. So it's important to know who these people are, and have they done this kind of thing before. If it's a group that you're a member of course, then you have more confidence, because these perhaps are people that you have an association with for some time. So that may give you a bit of confidence. But understand there could be pitfalls. Until you get that title, it's a risk just like any other.
Okay. All right. So let's talk about something else. But I think our culture, we don't necessarily prepare for when we die. So you find that most of the time we don't have a living will. And maybe Mzee had, a few property, and now the children that are left are fighting for the property. So first of all, can you tell us, Meg, how do you get a living will? Let's just get started from there.
So I think in the US we tend to call it a living will, but I think in the Kenyan context we just refer to it as a will.
Okay.
And of course, a will is where you get the opportunity to tell your people, first of all, things like where you would like to be buried, and that tends to be even a big issue, because of course where you're buried, that has implications on that property. So your question is, what do you do?
How do we get
a will?
Yeah, how do we get a will in Kenya?
Yeah, I mean, so you just write down your wishes. You have to identify all your properties, and then you have to be able to say, to this person, I wish to leave this. But it gets complicated when you have more than one, if it's a man, if he has more than one wife, if those wives are still alive, and if they have children. Because then at that, and if you also have dependents, as you will know that in Kenya, we tend to not just have our families, we tend to have other people who depend on us. So you could have a wealthy man who is educating somebody, a certain person, maybe for Form 1, Form 2. So even that person may have to be factored into the will because they're dependent on their estate. So the first thing would be, Monica, identify all the property. Identify all the people who are likely to benefit. That is your probably immediate family, which is wives and children, plus your dependents. And then now begin to say to whom you will leave what. And you also need to know, even if you put it down on paper as a will and it's properly witnessed, it could still be contested in court after you die. Because if one person says it is not fair that this was left this way, and the other one says it's not fair that this should have gone to this one, they can still contest. Better still, as you know, Monica, there's always a woman who will come up. She's always going to have another kid who says, even me, I should be put in the will. So if you've neatly, categorically divided the land and whatever else you had to a certain group of people, so what happens to the ones that were not in the will, but they're saying, I should be, this is my father, this is my husband. So a will is just a piece of paper. You write your wishes, a lawyer will guide you through the process, but bear in mind that if you don't include everyone and do it in a fair way, the likelihood of it being contested upon your demise is very high.
Okay, so I don't understand this, Job. If, this is my will, this is my property, I'm allocating it to certain people, why is it that then when I'm dead, that somebody else is going to make a decision as to where my property goes? What was the point of writing the will in the first place then? Job.
Well, Monica, yes, it's not as simple as you make it to be, because the law expects that. You can hear me?
Yes, I can hear you.
All right. Yeah, so the law expects that you're going to make provision, for all your dependents. So those people that you have been supporting in life, you also need to take care of them in death. So if you're making a will, then, and this is the point that Maggie was making, ensure that you provide for others. What will happen is that the will be challenged. It's going to be challenged because you've not made provision for someone that you were providing for in life. So that's the whole point. That,
okay.
If someone had depended on you in life, and yet in your will you have left them out, then of course there's intervention by the courts in that situation. So that is in essence why it appears like your wishes are not being
honored.
Honored.
Yes.
In death.
Okay. All right. So then,
yes.
Go ahead. Yeah. Go ahead, Job.
Yes. Sorry. Just add that as you make your will, where you're recording your wishes, you also need to ensure that you appoint in that will the person that will carry out those wishes, or the persons. There could be more than one. We call them the executors. So yeah, those are the people that you'll be entrusting to carry out your wishes in your will, and then ensure that you also have two independent. Kenyan law requires that you have two independent witnesses for the will to be valid. Okay,
so how much? What adjustments can the person I choose to be the executor, how much adjustment can they make, or how much are they allowed to make? Can they make adjustments to the will? Are they allowed to do that?
No. They should not make any adjustments. Because, yeah, they do not have that power.
Okay.
What they will be entitled to do is to petition for a grant of probate.
Okay.
Basically, the will to court for the court to give them that approval or power to carry out those wishes. Yes, the testator, the deceased, the person who made the will, entrusted you as the executor with those powers. The court needs to basically confer them on you, so to speak, within the confines of the law, so that you carry out those wishes. So you do not have the leeway to change the contents of the will or the wishes of the deceased. You do not have that leeway.
Okay, Meg, I'm sorry I cut you off. You wanted to add something?
Actually, I can't remember, Monica. I intended to add something, but I mean, it's just to highlight your concern that sometimes we go overboard trying to write these wills. But it's good for us to also recognize that they can, it's good to recognize that if your will is not fair, if you honestly, genuinely had other children out there and you don't include them, it's only unfair to the ones you include, because they'll have a big surprise when they go to court and someone else, pops up and says something different. So I just wanted to tell you that I understand your concern that why would you write a will and then, it's changed again. But I suppose the only way out of that is then let it be a fair will.
Okay.
Let it capture everything as it is.
Okay.
Yeah.
All right. So what about, our Kenyan culture allows more than one wife. you know.
Yeah.
And also too, I think the mpango wa kando out there that have children are allowed to bring their children, and that is why they appear as soon as somebody has died, you know, because they come and say, you know, even this child, you know, was so and so's child, so that they can also get something out of, you know, what has been left. So can you tell us how that goes? And say, for example, if the mpango wa kando woman doesn't have money to hire a lawyer, you know, and the person that died had a lot of money, so, you know, his wife has, you know, the money left for her, so the other person doesn't have a lawyer, how is the other child going to be included in the will?
Obviously, if you don't have a lawyer, so that you don't have any way of accessing the courts, it might be a challenge. But just on that point, it's good to highlight the fact that there are some well, I don't want to call them Christian organizations, but there are some, like Kituo cha Sheria, which is more or less, they do a lot of pro bono work. So if you ever find yourself in such a situation, you can't afford a lawyer, some of these institutions can assist you. So you can get some type of legal aid in that way. But if you are a child who has been left out of a will, if there was one, and you don't have a lawyer, then unfortunately, it's like as if you've slept on your right. Because if you don't move the court in one way or another, the court won't move itself for you. It won't know you're there.
Right.
So unfortunately now there, it's to your loss. So if the only advice I would say, if you find a lady that is in such a situation, let them approach the Kituo cha Sherias of Kenya. And I think there are a couple of them. And even some lawyers, if you approach them, you know, they can have that compassion and do it for you pro bono.
Okay.
You know, so in that way you can have the rights of your children protected, because they are children and they in every way deserve whatever their parents had for them to start them off in life. Yeah, absolutely.
So is that when then that if this child wasn't known to the family, we have to do a paternity test to make sure that they were the deceased child's?
That might be necessary. In some cases, it's not necessary. If the kid turns up looking completely like the deceased,
okay.
You know, you just accept.
Okay. All right. So, Job, I want to ask you, what if we don't have a will? You know, there's mzee head shamba here and there, and now the kids are fighting. You know, so we don't know, you know, how to allocate what to who. You know, so if there was absolutely no will, where do we go from there? Or maybe it was just one kashamba, maybe 5 acres, and there's 7 boys. So, I mean, you know, some of them, they say girls, you know, are not getting anything. So where do we go from there?
You know, in the case of a will, the executor will approach court for grant of probate. In the case where someone has a will, then the family members, starting with the spouse, approach court for, you know, to petition for a grant of letters of administration, intestate. So in either case, you approach court. What happens is that in an intestate situation, you know, the surviving spouse is one who is entitled to a life interest, you know, in virtually the estate that has been left behind, because they'll also be entitled to some of the personal effects, household goods and stuff like that. So the children ideally should inherit once their surviving parent passes away. That is the intention of the Law of Succession Act that governs situations like this. But oftentimes what happens is that the family will approach court once they have petitioned for that grant of letters of administration. They will then agree that these are the properties that were left by the the deceased parent. They will tell the court that this is how we have agreed to have the assets distributed. So there will be a schedule showing property such and such goes to so and so, or to 2 or 3 people to share equally. Basically, they will have agreed on a fair distribution, and the court will require that they all give their consent or confirm that they are comfortable and agreeable with the way that the sharing has been set out. So at that point, even if the surviving parent is there, the children may actually have the assets distributed to them by that agreement, common agreement amongst them. So unless there is a situation where someone has been left out, because as you file your petition for the letters of administration, you're supposed to list everyone that was a dependent of the deceased. So unless someone was left out at that stage, it should be a smooth process. You've set out all the assets, you have all agreed on how it should be distributed, and you are all comfortable with that distribution. The court will confirm that, and you'll be able to present the papers that then you get from court to the relevant institutions, whether it's a title that you're presenting to the lands office to change from the name of the deceased parent to whoever has been agreed upon, whether it's shares in whichever entity, whether it's a car or any other asset. So you'll be able to effect distribution as agreed.
Okay. Right. So Meg, what if we have 2 wives? Do they get 50-50?
It depends.
Okay.
Because in most cases, the wives will not have come at the same time. Such that you have the first wife who maybe, let's say, was married in the 1970s. So when she came in with her own property, or rather they together, the man and the woman, developed their own home, especially what you would now refer to as their matrimonial home. They set up maybe a business together. And then maybe another wife, the second wife maybe comes along another 20 years later. So there's a way in which, again, it still depends, but ideally that which was for the first wife, especially if she's still alive, although her children can still get it, that which was for the first wife, which they built together, is hers, together with her husband. Now, whether it goes 50-50, or I mean, at this point, the husband is dead anyway, so that would be hers. That would be hers. But whatever has come later, which let's say if the man had now put up a home for the second wife, maybe in another area, there's no way, I don't know, maybe Job can help with this, but I don't think the first wife would have a claim on that of the second wife. You see what I mean? So, built for you, that is yours. What was built for the second wife, because probably they built it together, then that is hers. But again, you can find if there was a business which was benefiting both houses,
right,
or a property, let's say there was a building flat, maybe they are flats, and they were benefiting both houses, it would be difficult to now say this one was for the older madam, this is for the younger. Chances are the court will look at how to divide that equally, depending on the needs of the dependent.
Okay. So, yeah. Job, okay. In America, they usually force people to sell the property, divide the money. Is there anything like that in Kenya? If we can't agree, sometimes maybe it's just one, piece of land, or maybe one, small plot, that it really cannot be divided any further for anybody, for all parties involved to get title deeds. Can the court force us to sell it and then we just divide the money?
Yes. In situations like that, where it's not possible to, do a fair division of the property in question. Yeah, the court is likely to, basically ask the parties to sell the property and then divide the proceeds amongst themselves in, certain share. So that happens. Sometimes it's even the parties who will suggest to the court that yes, let's instead of dividing this property, it may be impractical to divide this property. Let us sell and divide the proceeds in this manner. So yes, it's an option and a practical one.
Because as Maggie were talking about, if the house was built for the first wife, then she owns, that house and that property. But there are some cases where, two houses are actually built on the same land. So what do we do then?
Again, it depends, because what if the land is a 5-acre piece of land so that it can be divided?
Okay.
But again, remember, so the problem with that is probably the land was bought by the mzee and the past wife. And then now he's gone along and gotten another wife, and then he's taken a portion of it and put her house somewhere on the corner, or, he has apportioned a bit of it.
So are we going to kick her out, or?
You can't wish her away. I mean, honestly, you would want to, but you can't wish her away. So, and another thing is, in some of these situations, actually, the parties do go back and they agree. Actually, I'd rather if you just sort of buy me out or something, as into a channel. You know what I mean? Like, it's not all you would have to follow each piece of the law as it is. Sometimes, as even Job was saying, the parties will just agree and say, you know what, instead of us living here and fighting all the time, why don't you keep both houses? Let me have the other shamba, let me go build. Maybe there was also money in the bank. Let me take a larger chunk of the money in the bank, I go set myself up. But the question you ask is very good and valid, because if you have a piece of land which you bought together, the first wife and they bought together, the question would be, what right does now this other lady have?
Okay.
What right does she have with her house that has been built for her? But again, that would be her question. So if I was the judge in such a matter, probably I would ask for subdivision for that piece of land and she goes away with that. That's probably what I would think. But I mean, Job, I don't know what you would say in such a scenario.
Yes, I think, of course, each case is, determined based on its own circumstances. Yeah, but, the scenarios that, you're offering do happen. So you have to find practical solutions for them. Trade off one asset against the other, buy out or pay off one party so that, they take the money, you remain with an asset. So practical solutions have to be found, because at the end of the day, the parties have to basically get, the inheritance that they have agreed to or that was given to them.
Okay.
However, in practical, it may be to divide, to do, the kawaida division of assets. So practical solutions, have to come into play at some point.
So, Job, something that I know you have done is in case someone has, passed away and we don't know all the property that that person had. Can you talk to us about that?
So this person, this property owner has passed away, and you're not sure what assets they have. Yes, it presents problems. It presents difficulties in this sense. At the point when you're approaching court, you're petitioning for the grant. You have identified assets. As much as possible, you've tried to search records, documentation, whatever they have, to see what assets they have, and your search has yielded, certain assets. And in reality, they're not all the assets that the deceased had. So what happens is that rather than taking time to be able to do a complete search, you may decide that let's because certain of the dependents are still looking at whatever was left by the deceased for their day-to-day living and sustenance. So you cannot say that you're going to wait until you identify all the assets, or you're completely sure that all the assets have been identified, and that may be several years down the road. So you present your petition, with the details of the assets that you've been able to identify. So as you go through the process in court, if other assets are identified, then before what we call the confirmation stage. The confirmation stage is the stage where you have agreed, you have given the court the proposed distribution amongst the family members. So before that stage, you can then bring in any additional assets that have been identified after the filing of the petition in court. So, and that is allowed because it's known that this is likely to happen, that not all assets were identified at the very initial stage of petitioning for the grant. So you can bring those assets before the confirmation stage. But even if other assets are identified after the confirmation of the grant, where the court has okayed the distribution, you can still go back to court and with an application and tell the court that, look, while we were able to confirm the grant previously with the assets that had been identified, we have now established others, and we have, and these are the ones that have been established since, and this is the way that we have agreed that they can be distributed. So the court will do a rectification or an amendment of the certificate of confirmation to add those additional assets into the distribution that had been okayed by the court previously. So that can happen. So I personally have handled a case where we have had to go to court a record 4 times after confirmation. So 3 months down the road, 6 months down the road, new assets are unearthed, and you have to go back to court to tell the court, look, we are back again. We have now identified these additional assets. Please, allow us to distribute them in this manner and add on to what was previously brought to court. Okay. So that happens.
Okay. So I actually forgot to ask another question. Meg, what if someone in diaspora has bought a plot, because they're here. So they buy a plot in Kenya in somebody's name. And how do we go back to Kenya? Or even if we can't go back to Kenya, how do we get those plots to be in our names? I mean, can they do email or, how do we do that?
So it depends on how they put it in their name. What I mean is sometimes you can have a title, like I can have a title in my name as Maggie, but I'm holding it in trust for you. So that your name is there, but it's just that I'm holding it in trust for you. Or if it's a scenario where for sure you're saying I have bought it in my name, but for you, so then the only way out of that is a transfer. For you to do a transfer, you need to, now they've made it simpler. There are all these forms, and I think Nairobi, I practice in Mombasa, and I think we are not behind Nairobi, because Nairobi, I think their electronic thing is better than ours. But either way, it's still a process. You would have to do the transfer form, take them to the registry. That should be accompanied with pictures, your ID, if hoping that you have one, or a PIN number. And in most cases, most people in diaspora don't have their ID. Consequently, they also don't have a PIN. No wonder most of the time, these things are bought in somebody else's name.
Right.
That is so. And the minute you do that, the problem is you now attract for yourself another cost of stamp duty when you're doing the transfer. Because for me now to transfer to you, there's that, it's either 2% or 4%, depending on where the land is. So the question is, can you do it electronically? I know the old school way in Mombasa, we are not yet there. I don't know whether in Nairobi they are full swing electronic. I don't know. Maybe Job can tell us on that one.
Wait, what is the 4% you just talked about? What 4% is that you just talked about?
Stamp duty.
Okay, stamp duty. Okay.
Yes, because you're transferring the property from me to you, so stamp duty.
Okay.
If either 2% or 4%, depending on the location of the property.
Okay. All right.
Yeah.
Okay.
Yeah, so the challenge
go ahead.
So that's where the challenge is, that most people in diaspora don't have a PIN number, they don't have an ID, and if they have a PIN number, then they have to keep filing taxes. So maybe that's why some people don't take these documents, but unfortunately, transfer is the only way out of that.
Okay.
And hoping that that person doesn't die.
I was going to ask that. If they die before they transfer, then what?
You know, hopefully you also had an agreement of sorts. You know, if you had an agreement of sorts between the two of you that, you know, you hold this land of, you know, for me. But the truth is, the people who say, for example, it's in my name, I die, so everything now moves to my husband. So my husband will be saying, this is my property. Monica is saying, no, this is my property. But if there's a type of an agreement or some type of understanding where you're saying this transaction for this and this reason, so at least the court can buy into that. You know, but it's all a matter of now whose evidence is better than the other. But, you know, these situations, they do come up a lot with people from diaspora.
Okay.
But on a light note, I don't see why we cannot now start taking identification documents, although the challenge will be biometric. Of course, we cannot travel, but I want to believe that at Washington now you can do that.
Okay.
So that you have the thing for yourself. This thing of you hold for me, I'm coming. Challenge.
So, Job, is Nairobi more electronic? Can we do this electronically, by email, fax?
Yes, the Lands Office, the Ministry of Lands, has put in place what they call the Land Information Management System, LIMS. So through that platform, then you're able to do quite a number of transactions. You know, you can carry out a search online from the comfort of your desk. Whatever payments need to be made can be made through M-Pesa. So the system has simplified a lot of some of the more complex, you know, processes. So registration as well. The Lands Office in Nairobi has several registries. You know, so not all of them are online, but there's quite a big push by the ministry to ensure that everything is online. Right now, they're doing a bit of you know, of work on digitizing a lot of the records, some of the old records. So not all of them are online, but a fairly good number of them are available online. And you can do your searches, you can do your registrations, you can pay, you know, for consents, whatever you need, you know, you can process that online.
Okay, so I am looking at what people are saying here, and I see Washon Dirango, she's saying that people do not respect agreements, others just disappear. Now you've not even seen that land. Those are the things that we go through. So let me just see if there's any question here. Let me start from the beginning. Dorothy, you can play a song as I look. The title deed is most useless.
Can I also say something?
Yeah, you can.
So, you know when you say people don't respect agreement, well, an agreement is an agreement. If you can get to a court of law, they will respect that agreement. As a matter of fact, the court won't even rewrite your agreement. It will take it as it is. Unless, of course, there's something illegal about it or something. So based on that agreement, you can go to court and say, this is what we agreed, but this person breached the agreement in this way, and so I either want my compensation or I want this person to be forced to do this on my behalf, which we call, you know, injunctions, mandatory injunctions. So anytime you have an agreement, you shouldn't lose hope and feel like it's a worthless piece of paper. It does have some weight, especially if it's also backed by some evidence. Like for instance, if you're in diaspora and you sent money home to this person, based on that agreement, now you add those things. You add all those Western Union receipts, all the emails you exchanged, and that by itself is good evidence. So you can use that. The other thing that person has said is sometimes you buy land that you haven't seen. Now that one actually is the most dangerous part, because sometimes someone will buy you a piece of land, but it's an entire hill, meaning you thought you would build a house on it, but it's such a steep slope. So some of these things you would have to get other people involved to help you maybe go and see the land, so that you're not buying. Yes, you're buying a piece of property. You intend to one day come home and settle and have some cows, but the land is so rocky. It's so rocky. You can barely do anything on it. So when it comes to land, you need to now get somewhere, and you won't lack somebody who you're just paying the money to just go and view, let them see, rather than only relying on the person selling to you, even if it's a relative. Send another relative, tell them, go check for me. Is the portion I'm being sold to this shape? You could also be sold for a rectangle like this. So you want to build a gate, you want to put a house, but it's an awkward shape. You know what I mean? So you also have to go there. You have to send somebody to be your eyes. And nowadays with video call, let them also go and take their video, and then you can also see that you need to see the soil. You need to see if it's close to some type of a wetland or something. So nowadays with a lot of technology, it's not like before. It's not like before. Now you can use everything available to you to make sure that what you're buying makes sense to you.
Okay. All right, so I'm looking at the questions here, and I see Washon Jirango. She says, land subdivisions, agriculture, pastoralist, land being sold to unsuspecting diaspora, many of whom think or assume the land can be used for residential or commercial purposes. So she says, educators on the fact that there is a minimum size and use of any land and change of users, common 10 by 100 and smaller subdivision. And her second part question, she says, when family take out family members of an inherited property title without their knowledge. So let's just go. Job, can you talk about educators on the fact that there is a minimum size and use of any land and change of user, common 50 by 100 and smaller subdivisions? Can you educate us on that? That's Washo Dirago's question.
Thank you for that question from Washo. Yes, there is I think there's still pending legislation in Parliament to provide for minimum and maximum acreages for land. And this is a requirement by the Constitution. So that has not been enacted as yet. But what you have is limits on sizes of land in terms of zoning. There are certain areas that have been zoned. Say for you cannot go below a quarter of an acre, you cannot go below half an acre. So some of those zoning restrictions are in place for certain places, but you do not have as yet, as far as I'm aware, and I don't know whether Maggie might have a contrary position. There is no law as yet to provide for minimum acreage of land in Kenya. Besides zoning restrictions, we also have the Land Control Act that essentially was meant to be a check on agricultural land, so that it's not subdivided into small insignificant strips that are unproductive. So that in a sense may come into play as limiting the size of land, but it's not expressed as to what acreage you cannot go below. So those are some of the things that are there. The other question was on change of user. Yes, land in Kenya is it has different user, so to speak. You have agricultural, you have commercial, you have industrial, you have land for pastoralism and all that. So if you're buying a piece of land to do a certain project, you better check that the user of that land is in line with what you want to do. So if it is not in line, then you may want to find out whether it's possible to undertake a change of user. So, for instance, in Nairobi, a lot of, because of the zoning restrictions, you had land that was restricted to, say, a single dwelling, basically a single house, say on a quarter of an acre. But due to increasing population, it has become necessary to do flats, what we call multi-dwelling units. So before you put up a flat on a piece of land that still has that single dwelling user, then you need to have that change of user, undertaken. So again, in the case of agricultural land, if you want to do, an estate or a gated estate for that matter, then again you need to undertake that change of user to be in line with the user that is allowed for that land. So that is, in essence, what change of user is about.
Okay. All right. So Meg, can you answer our show? And she says, when family take out family member of an inherited property title without their knowledge, can you address that?
Okay, well, I don't really know what she means. I don't know if she means the title had her name and they've taken it off somehow. But maybe the essence of what she's trying to say is she was supposed to be inheriting a piece of land or a property of some type, and the estate has not been distributed to her. So as Job explained, the process in which you get your confirmation of either grant or letters of administration. Letters of administration is when there was no will. So in that case, there is a provision for if there is an objection. So if you're objecting to what somebody is approaching the court to do and you've been left out, then you can object at that point. And so at that point, it will become a contested case. So if you're able to show you're a family member, of course, birth certificates and all, then now at that point the court should deem it fit to include you as part of the beneficiaries, and then that way the property can be distributed to you. So I hope that is what she was asking.
Okay, so and I have somebody here that is fired up because of you mentioned that when you die, your will could actually be adjusted to make it fair. And so I have Lucy Tifase here, and she says I disagree with that. If I have a will, I expect it to be honored by all means possible. Nobody should change my will, period. And she says, can you please address this? Job, do you want to take that? Go ahead.
Yeah, so that's why I was saying that you can do up a will. That will, if it's taken to court and nobody contests, it can go well and fancy such that now that the distribution is done according to the will. But what do we do? A man who had three wives. Each wife had maybe 4 children. You've done up a will and only included the last family. So once that will hits the court and these people object to that, the court will have to decide. The court will have to make a decision and say, you know what? This appear based on the evidence presented to us, we agree that these are also children that should benefit from this estate, or these are wives that should benefit from this estate. So when you're doing a will, you need to factor in fairness. If for sure you had 3 women, the 3 women had 4 children each, and then on top of that you had dependents, people whom you are taking through school, it is only fair that you make provisions for all of them. If not, unfortunately, and this happens a lot in court, that will be contested and therefore it will be adjusted. Such that whatever you had written down on paper, it's as if you might as well not have written it, to be honest. So when it comes to will, fairness is the key.
Okay. So
do what you want.
And I totally understand that, but Job, I think the problem with us Kenyan people, and it's not a problem, but that's just how the system makes us. It has made us think that way. We don't have confidence in the system, and that is why Washo says here, and she's responding to Lucy that said that was not fair. If she dies, she expects her will to be executed as she wrote it, and so Washo says, correct. This is how executors kick out some family members of property inheritance. job.
So what was the question, Monica?
Okay, so she is confirming, or she's agreeing with Lucy, and like I mentioned before, I think we do not have, we don't trust the system, and so Washo says here that we use executors to kick out some family members off of the will or of inheritance. Do you know if that happens?
It might happen, but remember the job of the executor is limited to carrying out the wishes of the deceased, and the deceased will have indicated clearly that I want this particular piece of land to go to so and so. I want the other one to go to so and so. So the executors really have little room, to in such a way that they're able to disinherit anyone or to favor others,
right,
so to speak.
Right.
So, but if the will is worded in such a way that the executors have more substantial powers, where you're bringing in, say, discretion, you're giving them discretionary powers on what to do, then of course they can misuse those powers to sort of prejudice some of the people who should be inheriting or benefiting under the will.
Right.
But if it has been done properly and in such a way that it's clear what has been bequeathed to which beneficiary, then the executors may not have much room to play around. Yeah.
Okay, so again, I have Washo. She's saying, how will diaspora know they are being sold land that cannot be subdivided into less than an acre or so? Job, you talked about that, so you want to answer, Washo?
Yes, you need to do your background, checks. Don't rely on the information that you're getting from the seller. Look for other independent means of either confirming or checking the veracity of what is put out to you. If they say that in this area you can do this kind of building, or you can do this kind of project, or whatever other information they representation they make to you, double check that with independent sources. You can get other people to check out if you're not able to do it because you're in the US or overseas or out of the country. So you can find third parties that can do the necessary checks to ensure that whatever representations are given to you by the seller add up. So that's important. The problem is that sometimes you rely entirely on what you're told by the seller, and of course they'll have a very nice sounding marketing whatever PR and all that, and then they have netted you and netted your money, then they have no obligation to live up to whatever they put you up to in the first place. They'll just take your money and bolt. So ensure that you double check before you commit.
Okay, so I had a question from someone. She actually just sent me a question, and I think, let me try to see how I can put this for her. But this is what she said. I had a conversation with her before, and she said that if someone is legally married, and then they're separated, not legally separated, and so the husband goes ahead and starts living with another woman. So the first woman is not divorced, they're still legally married, but the husband moved on and is now living with another woman. If the husband dies, does the other woman have can the other woman have access to what the man had, or is it still going to go to the legally married wife, even though they are not together or they were not together by the time the guy was dying? Meg.
So, depends on how long they were together. Depends on the type of relationship they had. So that if she's able to show, for example, she had children, so you'd be talking about somebody who had a common law marriage. So now there would be two marriages.
No, legally married in church.
To the first one.
Yes.
So you're saying she's married, he married the first one in church.
Right.
They did not divorce, but then he went ahead and had another wife. And they were living together, and now he has passed away.
Right.
So the question is, what does the woman who came second in time, does she have any claim to his property? That's the question.
Right.
So assuming this woman had stayed with him for, let's say, 2 years, a year, they had children together, they had set up things together, then it would make her what you call a common law wife. Meaning she doesn't have a document to show for it, but there's so much going on for her that she can say, this was my husband, because she can say traditionally he brought the mahari. He can show these are the children that we have. This is the house we put up together. So let's say there's a big amount of money. Let's say there's a 10 or 100 million in the bank account. So the question would be, can she access that money? My answer, going with the scenario I have painted, my answer would be she's entitled to a portion of it. How much of it she's entitled to, I don't know. But she would be entitled to a portion of it because she is a wife. She is a beneficiary of his estate, her and her children, the same way the other one and her children is a beneficiary. So I think the main issue here is who do we call a wife? Who does Kenyan law deem as a wife? Is it only somebody who has a piece of paper, they went to church, they have a marriage certificate to show for it? No. If you have lived with a man for a significant amount of time and you've done, you've got maybe children, that would be the best evidence, you are a common law wife. You are a common law wife. Because marriages can take place through various means. Like now you have Hindu marriages, you have Muslim marriages, you have the Christian type of marriages, you have the one where you go to the Attorney General. All of those are marriages. You have the customary one where it's just come, let us stay, but I'll take dowry to your home. All those are marriages. So she just has to prove which one she had. The one had the Christian marriage, the other one had a common law, a customary marriage.
But do both women both women then able to inherit?
Yes, it's just a question of how much and who takes what.
Okay, so Job, what if the second wife or the second woman doesn't have children? Is she still entitled to get something?
That is a question that the court would have to deal with and weigh all the factors, which is what Maggie is alluding to. The length of cohabitation, when they presume, because there's you can be presumed to be in a marriage under common law. So and that question has spawned amendments that are pending in Parliament. There's a bill that was prepared and presented to Parliament last year. It has not yet been passed, seeking to amend the Law of Succession Act, and particularly the definition of a wife, to limit that to a wife in terms of the Marriage Act, someone who is in a marriage that has been registered under the Marriage Act. That is to take care of scenarios like what has been brought forward, where you have someone. It's unclear what sort of union is there. Are they, married, and what system? Are they? Is it common law? Is it? What is it? What relationship exactly is it? So to avoid those kinds of hard questions, even for the courts, then the law is seeking to bring clarity by defining who a wife is. And that is someone who is legally married and the marriage is registered under the Marriage Act. That would be, of course, either you've been married in church, you've been married at the Attorney General's office, you've been married any of the other systems, either as a Hindu, Muslim, or even cultural, which has been, there's provision for registration of our traditional cultural marriages. So there would then be no question who you are. So if you are someone who has been cohabiting, you are not a wife in terms of the inheritance law, and that would then take care of a situation like that. So they would not really be inheriting because they're not recognized as a. Yes.
Okay, so I'm looking at what someone is saying here. Like I was saying earlier, sometimes we do not have, we just do not trust the system. And so I see Karen Wigai here. She says that is why they do it. I'm not sure who she's responding to, but she says that is why they do it. They bribe the courts to bring the cases after every 3 months. You go there after paying like 1,500 ticket, and the case is adjourned for the next 4 months. Finally, you in diaspora give up and they win. It's a game they know how to play. That's what diasporans are saying. Meg, you have anything to add to that?
Yeah, I mean, it's true. There's what I call mchezo ndani ya mchezo. And it's frustrating. You know, bureaucracy, the way it works is through delay.
Yes.
Just by delaying things, it creates frustration upon the person who is seeking to consume a service. You bribe. But the good news is, though, nowadays, most of the things are done virtually. Like now, I attend courts. For example, like tomorrow I have a court session and I'm doing it virtually from America. So the beauty of it now is most of these courts are now virtual. So some of these delays that you have seen taking place, such that you give up and you come back to the country, to the US, it may not have to be like that anymore. You could still have your lawyer, engage them. You can still do it now virtually. And we must thank God, that COVID happened, because COVID brought all these exciting changes in our court system. Yeah. So, but I understand that frustration. It does happen. It does happen. And because the courts are, although they have increased the number of magistrates and judges, but before it was that the courts were overwhelmed. So that sometimes it's not really what I'm saying, mchezo ndani ya mchezo. Sometimes it's just the system is like that. It was overwhelmed. And it probably still is to an extent, but not as before. So take hope. Now you can log into court virtually. You just engage your lawyer and let them give you the link, and then you can at least see the progress of your court case. So all hope is not lost.
I know someone is sending me a message. They say that they've posted their question, but I don't see it. But I see Lois Njeri. She says, in which land is one supposed to pay land rates? Freehold title land, lease titles, or just any land, especially when it is not in use? Job, you want to answer, Lois?
Yes, land rates are basically payable to the county governments. It's in respect of the services that are rendered within the county. Principally, it was within the municipalities, sewer systems, the roads, and all the services basically within the city or the municipality. So that's the land rates. Then we have land rent, which is basically money that is paid in respect of land that has been leased to you by the government. If you're holding a leasehold, property under a leasehold, then you would be paying land rent. So that's the distinction.
Okay, so Lois, I think your question has been answered. Let me see, can you virtually participate in argue? Yes. Okay, so so I see a question because Maggie, you just mentioned about court cases are being done virtually now, and she says, wow, this is good. Can you virtually participate and argue your cases? That's why she was saying that.
Yeah.
Go ahead.
You can. That's what I do.
Okay. Okay. So which means you can actually practice from US. You can practice from wherever you are then?
You know what? That's why I say thank God for COVID. If it were not for COVID, and this would not have happened that soon. So yes, I've also had a scenario where I put my witness on the stand virtually. So I'm able to have them produce their evidence, and then they're cross-examined. Some lawyers will say, some opposing lawyers will refuse to having a main hearing done virtually, but sometimes they agree, and it makes it all the much easier. Rulings are delivered in the same way. Nowadays, we file our documents online, and then, you pay by M-Pesa. So the system has improved greatly, and we really thank God for that, yeah. So yes, I'm able to file cases while I'm still in diaspora.
Okay, so Maggie, you're telling me that you've typed your question. I honestly cannot see it. I'm going through. Sometimes when I'm doing live, I don't see all the comments. I probably see the comments after the show. So if you can send it to me on WhatsApp, I will ask your question. I can't see your question, Maggie. I am so sorry. I apologize. And Danu, I agree with you. Why victimize her if she can't have kids? Not fair. And she was just talking about the other woman. I think that's all the questions I see. Let me see Maggie here. Maggie, I can absolutely not see your question. I just can't. If you could type it to my WhatsApp, I will ask your question. I am so sorry. I apologize. It's just how the system is. But let me see. Let me try one more thing so I can get her question, because she's going to get on my case after. No, I don't see it. Maggie, I can't see your question. I'm so sorry. What question, Lois? Dorothy, music. I'm waiting for Lois. And I'm so sorry, guys. Give me just 1 second so I can get this question. Dorothy. Okay, Lois, I don't see your question. Okay. Okay, all right. Okay. Thank you, Dorothy. All right. Okay, so I just received a question from someone, and she was just asking, I think we already answered this one. Maggie, I think you talked about this one, and she's just talking about can a come with stay person, they have no children, or they come with children from previous marriage, they have no children but live together, but the man is still legally married to another woman. That's what you were talking about. So if children came from a previous marriage to now the current marriage, would they qualify to inherit something? And also they agreed never to marry. And also if they agreed never to get married. Did you get the question?
Okay. Well, it's multifaceted. Maybe let me go for one piece at a time. Mm-hmm. When you say they agreed to never get married, but they were living together as if they were married. Mm-hmm. So that one is a tricky one, because then we don't know whether she's becoming, whether that kind of a lady would be coming to say, I am married to this guy, therefore I need to be part of this estate. Or maybe she'll be saying she's a dependent of some sort. Mm-hmm. Maybe unless she argues it as if she is a dependent. Mm-hmm. Now, if she came with other children, mm-hmm. the first question is, were those children also dependents of that estate? Because they are not his. And assuming, here we're making many assumptions, assuming he had obviously never adopted them in any way, so that maybe he was just supporting them. It could also be that maybe he never supported them. So if he never adopted them or supported them, then no, I would think they don't get to inherit.
Okay.
But if they were depending on him in one way or another, then as dependents of their state, they can benefit.
Okay.
Of course, if they had adopted them, then they would not be able to. So they would benefit from his estate because they would not be able to say, we also have other parents. You know what I mean?
Mm-hmm.
Because children who come with mothers, if no formal adoption process has been done, then even if you were to look at it without even putting the law aside, it means they'll eat from this house and then they'll run to their fathers or their mothers, probably their father's house, and also lay a claim in that one. So what I'm saying is, if they're able to show they were depending on these estates, then they can benefit. If they have been adopted formally, of course they will benefit. If they were not depending on that estate, then I don't see how the law will allow them to be part of, to enjoy something that belongs to others.
Okay.
That would be answering one question. So I don't know what the other question was.
Okay, but that's also too, Maggie, if this man has a will and he's already stated how he wants his estate to be divided, still the other woman with her children from a prior marriage, still she doesn't get to inherit anything. But again, I guess, you know, this may be to a catch-22 because customarily she's married because she lives with him, right?
Yeah, if she's married and the will has excluded her, at the point where it's taken to court for the grant of probate, she can object and say that, look, I'm supposed to be in this will. I've not been catered for. And then she'll be able to show evidence that she is a wife, a dependent of that estate. On that basis, then yes, she will at least qualify to get some type of, she will be a beneficiary of the estate.
Okay.
But
all right.
Where my concern was is if she had children from, of course, another man, the question would be, what do you do with those children?
What if the children are grown? What if the children are grown and working?
Yeah, so if he was not supporting them, that means they will benefit from their own father's estate. But to be honest, I have not handled this particular question, although I'm just also raising what I would think is a concern on my behalf. So maybe Job can, if he has handled such a thing, enlighten us on what do you do with these other children. But if they're, of course, if they're older, if they're like 20-something and they were not depending on him, I don't see how they benefit. But maybe I would also want to hear from Job on that.
Job, do you have a different perspective?
Yeah, okay, not really different, but let me say this. You know, this question has several facets. You have the position of, you know, the woman who's coming into this relationship with the man, and she's coming in with her children. You indicated that she's not legally married to him. It's a come, we stay. So the children that she comes into the relationship with, then ride on that status of this woman. So if it's a come, we stay, and the children are below the age of majority, then they
you mean age of 18?
Yes, the age of 18.
Okay.
Likely then to be supported by the man. He may probably, you know, accept parental responsibility over them, in which event then they become dependents, as Maggie said. And as dependents, then when it comes to inheritance, then they would have an interest in the estate. If the man, of course, had made a will earlier on, and now the circumstances have changed, his situation has changed, then he needs to, you know, update his will. And this normally happens. You know, you have a will that was made several years back. The situation has changed. The will was not updated. So this is now the scenario that ends up in court, where the will is challenged, because some people have come into the picture, they have acquired rights and interest in the estate that is being left behind, yet they were not provided for in the will. The will was not updated. So they can go to court and ask that a fair distribution is done. So that is one. If, of course, the children are above 18, then again here there's no question of them being supported by the man or being dependent on him. So they would really have a very tenuous claim on the property belonging to this man. So that's another scenario. So you can see the different scenarios that come into play that would then give rise to certain legal rights and certain problems for the persons who is trying to persons who are trying to claim any property from that relationship that their mother has come into.
So I have Stacy Mweni here from UK, and she's asking, what if the children are grown and they are still dependent on this parent that's gone? Because you talked about the age of 18 job. So what if the children are grown and they were still dependent?
Yes, well, again, the circumstances have to be looked into. How long has have they been dependent on this man? What's the length of time that they have stayed with this man? Was he supporting them? If he was, are there other children that are entitled to the estate? So the court is likely to have to make some sort of fair balance, so that you do not sort of disinherit the children who are properly and legally entitled to the estate of their father on account of other children who have come in who are now adults who should be fed for themselves. You can't treat them equally. So the court would have to do some balancing to find what is fair in the circumstances. So fair does not mean that they have got to be treated equally. Fairly, where that the ones who were the children of this man may get more than these ones who have come in and they're adults, but yet were still being supported by this man.
Okay, so I've gotten a message, a threatening message from a friend here, Lois Jerry, and she tells me that if I had already asked this question, I need to repeat the question again. So she says that she needs a job. I think you had talked about this, or I'm thinking you had already talked about it, but just talk about it again. And she says she needs to know the difference between a freehold and leasehold title.
Right. Yes. What you get, the interest that you acquire in land can be either what we call freehold or absolute ownership, if there is anything of that sort, where you own this land. You do not need to pay anyone. You do not need to pay the government any money for holding that land. So that essentially is a freehold, or what we call absolute ownership.
Okay.
As opposed to leasehold. Leasehold is where the land has been leased to you for a term, a definite period. Just like you pay rent for a house that you live in, that belongs to someone else, a leasehold is that belongs to someone else, in this case, the government. So you have been given that land for a definite period of time, and in turn, you make payments, specified payments to the government for holding that land. Once the term is over, then the land reverts back to the owner, in this case, the government. So that is the difference. So for freehold or absolute, you hold it in perpetuity. You can pass it on to your relatives. For leasehold, that land will revert back to the owner after the lapse of a certain specified duration.
Okay, all right. I think we have covered all the questions, but I see here that Becky Shi was asking a question. Please, how can we know a fake title deed, and how can I get justice for being conned? We were sold a piece of land that had been sold 4 other times. Do you want to answer her, Maggie?
Yeah, well, it's an unfortunate situation where you have a title which has been, you have a property which has been sold 4 times over, and that happens a lot in various parts of our country. So if you're holding if you're holding a title deed, honestly, by looking at it, it might not be easy to tell whether it is genuine or not just by looking at it. Job had talked about this where he said you would have to go and do a search at the lands office.
Right.
And if you do, what you get is an assurance from the government that the title is indeed genuine. But what we then said was, what happens if there are 4 people holding 4 titles which are all genuine, all 4 are genuine? So the court would have to consider, of course, if you bring up the topic between the 4 owners and you cannot agree, then of course you would have to move the court. And the court would be looking at who really was the first in time. First of all, do you all hold titles? And if you all do, so who was the first in time? Most likely the court would favor that. It would also look at, was there fraud? It would look at what kind of fraudulent activity happened. And in most cases, for you to have 4 genuine titles, as in titles that came from the land office, for you to have 4 searches which are saying that the property belongs to each different person, it means that somebody in the registry is doing something wrong. And I think Bob also mentioned something to the effect of he has done a case like this before where, I think that's what he said, where the government now would have to, because the government participated in this, they would have, they probably gave a refund or something like that. And so then the court would nullify all the other 4 titles and then the other 3 titles and you'd remain with 1. So just by wrapping it up, I would say just by looking at a title, you can't tell. You can't tell if it is real or fake. Just because you've done a search might still not reveal to you whether it is real or fake. If people come and claim that they're the owners, then the only way is to move the court and let the court decide. Because that evidence will be produced. Yeah.
And so, Lois,
just I mentioned. Sorry.
No, I was going Job, because Lois is asking, but how can all the different titles or different searches be good? So maybe you can just follow up with that too. Job.
Yes, it happens. It happens. In fact, personally, I have been a victim. I was interested in a piece of land. I got, the title, a copy of the title from this person who was, the seller. Genuinely, he was the owner of this land, but he was a crook. So what he had done was work with some people at the lands office. Well, the original title, he had charged it to a bank. He had worked with some people in the lands office to create a parallel title. So the paper is genuine from the lands office, government paper and everything. So, and then he would organize in such a way that if you went to undertake a search, the search would be carried out on this parallel file that had been created. So you'd get a search that would show, yes, he's the registered owner, but there's no encumbrance. The land is not charged in a financial institution. So if a search had been carried out on the original file, of course that bit of information would have come out. So that happens, and it happens with the connivance of the officials at the lands office. So, and this brings me to the point that I was going to add to what Maggie had said. The reason why these things happen, that you have 2, 3 original titles over the same property, is because of the fraudulent actions of officials who are tasked to keep these records, you know. So, and the reason why they keep on occurring is because we do not hold those officials to account. So if you have, other titles that have been issued, and you have signatures appearing on those documents, signatures of land registrars or other officials in the lands office, they need to be held to account. If that is done, then you're going to find fewer and fewer cases of multiple titles, because people know if I generate a new title where there exists another title, because I've been given a few coins by someone, and they spend years in jail, then that kind of thing will cease and become a thing of the past. So that needs to be to happen. People need to be followed up. Officials who have done things that then lead people, innocent people, purchasers, to loss and damage. So that needs to be.
Yeah. Okay. So what you're saying, Job, and this is good news, is that we can actually sue the government.
Yes. You can sue the government.
Okay. Okay. So to do that, we need good lawyers like you. Job, I've sent people to you. Meg, I've sent people to you, and all the people that I've always sent to you guys, they always come back and tell me how good of a job that you guys did. So I want you, Meg, can you tell people how can they reach you? Maybe give your information, if there's a website they can go to, and then Job, we can come to you, you can do the same. That way people can reach out to you guys if they need, if they have further questions or they need your services.
Okay, so you can reach me in various ways. Right now I'm in Atlanta. I usually oscillate between Atlanta and Mombasa. So some months I'm in Atlanta, some months I'm in Mombasa. So if I'm in Atlanta, you can reach me on 404-438-5864. 404-438-5864. And that number has a WhatsApp as well. You can also reach me on my Nairobi, on my Kenyan line. That would be +254 703-469-511. That also has WhatsApp. And so through the WhatsApp method, you can reach me. I also have a website, which is Kariuki.com. It has a hyphen in between. Nguyo, that is Nguyo. There's a hyphen and then Kariuki. Just the way Monica has spelled her name, Kariuki. So Nguyo-Kariuki.com. If you log in there, you can always reach me. And on my website, I also have a place where you can submit a ticket. And, it will send me an email and I'll be able to see the question you're asking. And usually I like to call people back. So I'll probably call you if you're in the US, and I'm in the US, I'll call you through my US line. If you're in Kenya, of course, I'll always be able to reach you either way. So those are the methods in which you can access me. Otherwise, if you're physically in Mombasa, my office is at Kengeleni Arcade. Right before you get into town, if you're coming from Nyali.
Okay. Job, can you give us your information, how people can get in touch with you?
Yes. We are based in Nairobi, in Upper Hill. Currently, we are based at Taj Tower, 4th floor. Taj Tower is located along Upper Hill Road, right at the junction with Elgon Road. Upper Hill Road, junction with Elgon Road. We actually plan to relocate from there in January to still within the area in Upper Hill, Flamingo Towers on that floor. So that's the physical location in Nairobi. You can get me on my cell phone line, +254 722 847093. +254 722 847093. 7093, and that has a WhatsApp. I have an email where you could also reach me on. That's figure@wkn.co.ke. Again, figure@wkn, those are the initials of the firm, .co.ke. We have a website that is currently under reconstruction, wknadvocates.com. wknadvocates.com. That should be up and running in a week or two.
Okay.
So you can reach me through those different platforms.
Okay, all right. And I am getting a message here, a job for you from Lucy, and she says, can you call her? Lucy Tifase. She says, can you call her? So other than that, I honestly want to really appreciate you guys. You have given us so much information, and I think you have answered a lot of diaspora questions, and I am sure diaspora will be calling you with a lot more questions and concerns. And so thank you so much for allowing us time to ask you the questions, and of course for giving us your contact so we can have our questions answered. So thank you so much. Job, have a very good evening. Meg, have a good day ahead of you. And for those of you that are watching, Dorothy, thank you for the music, and of course for being my very able producer. Those of you that are watching and those of you that are listening on the radio, I appreciate you so very much. Until next time, we'll see you.